Mark Chenoweth, our Executive Director and General Counsel for NCLA, who will be moderating the discussion today. Go ahead, Mark.
Thank you, Judy, and welcome everyone to NCLA's first virtual luncheon law. As Judy said, today's topic is Governors Gone Wild, ruling by executive decree during the pandemic. NCLA originally thought that we may not be filing many cases or any cases related to COVID-19 or the lockdown. And the reason for that is that the police power is very broad, and we knew that challenging the police power could be futile or it could even be counterproductive. We could see bad precedents being set. Also, the elected governors are the main actors in these cases, not the unelected bureaucrats who typically feature in the kinds of cases that NCLA brings in order to rein in administrative power. But then we began to hear about worse and worse cases, ones involving real structural problems with the ways that governors and other executive actors were behaving. And so we decided to go ahead and bring some lawsuits and try to tamp down on the kind of power abuses that we were seeing, and to restore the civil liberties of Americans that we have seen being abused over the last few months. You will hear about several of these cases today. What you won't see are any cases that are based solely on a claim that someone's civil liberties are violated because they are forced to wear a mask in public, or that a governor is making a bad scientific judgment about the threat of COVID-19 and the scope of a lockdown. Again, these are still things that are largely within the police power of the executive, and these are not the kind of structural problems that our cases are talking about. Instead, where NCLA is involved, you will always see a claim that a particular statute has been violated, that a particular constitutional provision has been traduced, or that a governor or other official is trying to use power that they don't have in order to coerce citizens into doing something that they don't have the power to do under the state law or the state constitution. Several of NCLA's litigators are here today to talk about these cases, and we'll go to them in turn. But first, I thought that it might be great to hear from one of my colleagues, Harriet Hageman, who actually ran for the governorship in Wyoming here just a couple of years ago, and have her share just a couple of minutes with you on her perspective of how governors ought to be behaving during this kind of crisis and lockdown, and what it means to keep liberty in mind while trying to keep people safe in a pandemic. So with that, if I could turn it over to NCLA's Senior Litigation Counsel, Harriet Hageman.
Well, thank you, Mark, and good morning to everyone, or good afternoon, depending upon where you may be located right now. It's wonderful to have the opportunity to address this. Preparing for and launching a gubernatorial campaign takes an enormous amount of work, primarily because of the research and investigation that a candidate must do in order to understand all of the issues that he or she will need to address, both while campaigning as well as, if successful, when governing. In doing that, I issued a policy paper in my campaign addressing 17 broad subjects, and then I had 80 separate bullet points providing more detail. The purpose of that document was to summarize my position on what I believe were the most important issues facing Wyoming at the time that I was running for governor, including budget and finance, the economy, the relationship between the government and the individual, job creation, healthcare, regulatory reform, taxation, education, transparency, reform of federal land management, and others. The reason that that is so important today is that when you run for office such as governor of a state, you must recognize that you are responsible for addressing and balancing a wide variety of interests, and yet in every single decision that you make. Governors must understand that they may work in what may work in one circumstance is not going to work in another circumstance. A one-size-fits-all approach doesn't generally work on the national scale, but it often doesn't work on a state level either. And most significantly, I believe that governors must acknowledge that they are not lawmakers, and they cannot and should not be issuing executive orders that literally affect millions of people while also sidestepping the deliberative legislative process. Which brings me to what I believe was the most important commitment that a governor can make, which to his or her constituency, which is that we must adhere to and understand the constitutional framework within which we govern. That was my #1 policy position, and it was at the very top of the list in the document that I issued. That statement of loyalty to the Constitution was really my guiding light throughout my throughout my campaign. In contrast, Governor Murphy of New Jersey was recently interviewed in relation to the executive orders that he has issued. He was questioned about how his executive orders comply with the Constitution's. And oddly enough, Governor Murphy actually laughed and he said, "Constitution, Bill of Rights, that's above my pay grade. I didn't think about the Bill of Rights when I issued my executive order." Now, although that may be shocking, I don't think that it's necessarily surprising. And I believe that more governors ought to understand the constitutional framework within which they work. As I stated in my policy papers, our constitutional framework was unique in the world when it was created and remains one of the most significant developments in governing philosophy in human history. Our Constitution limits the reach and power of the government, with individual freedom and liberty being the cornerstone of our republic. Sadly, that is not necessarily a sentiment to which some of these other governors adhere. My colleagues will now regale you with the stories of what happens when governors do not have the same North Star or the same fidelity to our founding documents. Mark, back to you.
Thanks, Harriet. And the first case that we're going to talk about today is NCLA's lawsuit against the governor of Massachusetts. Don DeRosiers v. Governor Charlie Baker is the name of that case. And to talk about that, we have two of NCLA's litigators, Senior Litigation Counsel Mike DeGrandis and Litigation Counsel Jessica Thompson. Mike, over to you to just give a brief explanation of what the, well, let me say this first, and then the question I'm going to ask you is, why is it a problem that the governor has used the wrong statute? But for our audience, let me explain that in Massachusetts, the legislature there over time has passed two different statutes, one called the Civil Defense Act and another called the Public Health Act. And the Public Health Act actually mentions coronavirus in the implementing regulations. The Civil Defense Act only mentions hurricanes, tornadoes, insurrections, invasions, things like that. So it seems pretty clear to us when we look at these two statutes that when Governor Baker invoked the Civil Defense Act instead of the Public Health Act, that he was operating under authority that he did not have. Mike, do I have that right? Why is it a problem that the governor has used the wrong statute?
Why isn't it a problem to use the wrong statute? There isn't anything right about this, and we see the practical impacts of that as well. If you don't use the proper statute to protect public health, instead you use a civil defense statute, you end up creating a whole new problem beyond statutory interpretation. You end up with a constitutional problem. And in Massachusetts, the constitutional problem starts with the separation of powers. Massachusetts has one of the most robust separation of powers provisions in all of the United States, and they have John Adams to thank for that. Adams didn't just insist upon a separation of powers in the Constitution. He also insisted upon a phrase at the end to describe why the separation of powers is important. And so it ends that the purpose is to establish a government of laws and not of men. Now, unfortunately, in this day and age, politicians have used, overused, abused that phrase, so it may sound a little trite, but these are in fact very powerful words. Separation of powers is at the core of a Republican form of government. And if you don't have separation of powers, you have a whole host of problems like what we're seeing here, where a governor is using a Civil Defense Act to issue executive decrees. These decrees have the force of law. The laws that he's made through decree have altered private contracts. They have suspended validly enacted legislation and validly enacted regulations. He has suspended or burdened liberty interests. He has suspended or burdened property rights. And he's done all of these things without any semblance of due process. Where do I go if I'm a Massachusetts business and I'm shut down, but I think I'm an essential business? there's nowhere to go. There's no process. The governor decided on his own, using the wrong statute, that I must close. I can't appeal that decision. What if in reopening, the governor assigns me phase 3, and phase 3 hasn't happened yet in Massachusetts? And I think, no, I'm really phase 1 or phase 2 business. I have nowhere to go to change that. And what if, and this has happened to one of our clients, and what if you're initially a phase 2 business, but then the governor decides on a Saturday afternoon that he's going to split phase 2 into 2 parts, and now you're part 2 of phase 2. There's just no due process here, and that's a big part of the problem with using the wrong statute. When you have a branch of government that's not supposed to make law, making law, you end up with practical problems as well. The office of governor, and I've tried to make this clear when talking about this case, that we're not saying that the governor doesn't have the best of intentions. We're not saying that the governor is an incompetent administrator either. What we are saying is that the office of governor is ill-equipped to address these issues. And we see those effects. What started off as a health crisis is now a comorbid health plus an economic crisis, plus a social crisis, plus a spiritual crisis. The only way for Massachusetts to get out of this problem is to abide by the constitutional procedure. Let the legislature legislate. It has already spoken on the issue in the Public Health Act. And if Massachusetts needs a broader rule, broader law to address any unique feature of COVID-19, the legislature can do that. They're in session, they can do that at any time, and they should do that. So that's what I think is a problem with using the wrong statute.
Okay, terrific. What has the governor's lockdown done in Massachusetts, and how has that affected your clients?
Partially addressed one of the issues, and this is the core due process issue. We have one client who has a tanning business, and despite the bathing a room in UV radiation and that they use hospital grade sanitizer, the governor decided that she was a phase 2 business and she couldn't open until phase 2. And then partway to phase 2, the governor decides, no, never mind. She's going to be part 2 of phase 2. Another one of our clients has a hair salon. Now, fortunately for her, she was part of phase 1, her hair salon, obviously with some distancing requirements as well. But what was frustrating to her was that she was not an essential business. The frustrating part of that wasn't the nature of her hair salon, so to speak. It was really just the dynamic in her very small town. In her small town, the pizza place was open, the convenience store was open, the gas station was open, and she has a beauty salon. It is the cleanest business in town. Where does she go to appeal this? She tried and tried. She even started a petition and got a couple of thousand signatures on it, if I'm not mistaken. There's also a real concern. Well, we have a gym owner. Gyms are supposed to open in phase 3, and we've seen some stories in Massachusetts of straight up rebellion by some gym owners and the penalties that they've received from their local boards of health. But this particular gym owner is planning on opening in phase 3, but will the governor then relegate him to phase 4? We don't know. We can talk about phase 4 in a little bit if you'd like. But we see that there are liberty and property interests, as all of our clients have business licensing from local and state authorities, and they have no due process to appeal any of these decisions. And beyond our clients, I've spoken to a lot of people on the phone from Massachusetts about their problems, and a lot of them just don't know how to plan for their business. Many are going out of business and they're desperate.
Mike, tell me a bit more about those businesses that are slated to open last. I know, I'm not sure if this is the one you were getting ready to talk about, but not a client of NCLA, but I think there was a wedding planning business that just sounds like it's devastated.
Yeah, and I'll apologize ahead of time. When it comes to phase 4, I have such a visceral reaction. There's a chance I would go off on a rant, so I'll apologize ahead of time for that. There is a mother-daughter wedding planning business that about a year ago decided to branch out and buy their own facility. It doesn't have it's not an outdoor venue, it's only indoors. They got a loan for about $1.5 million, which she and her parents personally secured that, personally guaranteed that loan using their homes. And of course, that ends up being very bad timing since the governor decided that her wedding venue is a phase 4 business. Now, to explain what phase 4 is, on Massachusetts website, it's entitled New Normal. And actually, I'll quote it for you so I don't mess it up. I've got it right here. This is all it says. Quote, development of vaccines and or treatments enable resumption of, and then in quotes, new normal. I don't know about you, but that phrase new normal without any explanations what that's about doesn't make me feel very good. And I feel very, very sorry for those businesses that are stuck just waiting for this new normal. And the problem here is obviously they have liberty and property interests, liberty interest in pursuing the profession of their choosing, property interest in the licensing that they have received from local and state authorities. Again, there's no way to appeal this decision. And the governor has taken what was once a lawful business, turned it unlawful, and made their reoperation, re-engagement in commerce contingent upon an uncertain future event, that being a treatment or a vaccine, over which the business owners have absolutely no control. It's a complete constitutional abomination. And the inconsistencies abound. For instance, if your hotel has an indoor swimming pool, you could open that indoor swimming pool. I'm sorry, an outdoor swimming pool, you could open that phase 2. If it has an indoor swimming pool, you could open that phase 3. But if you have a water park, an outside water park, without a hotel attached to it, your phase 4, you may never open. Great Wolf Lodge, right down the street. I'm not making this story up. This is someone else with whom I've spoken. Great Wolf Lodge, right down the street, with a huge indoor water park, opens phase 3. It's just profoundly unfair. And other strange dynamics arise here too.
Well, and Mike, we've seen this around the country, haven't we, where sometimes the big box stores are able to open sooner or even were never closed, whereas the mom and pops are closed down. And that's the kind of inequity that I think most folks look at and they wonder if there might be a constitutional problem there. And I think part of your argument in Massachusetts is that there is a constitutional problem with that kind of arbitrary decision-making.
That's absolutely right. Bars that have sit-down food service, you can open phase 3. Bars that don't have sit-down food service, your phase 4, you might never open. It's just a horrible circumstance. You're talking about the smallest of bars. It's just an abomination.
Well, I'm afraid we're going to have to leave it there for now in our discussion of Massachusetts. For those folks who would like to learn more about the DeRosiers versus Baker case, please log on to NCLA's website at nclalegal.org, and you can find the complaint in the case and other materials as they become available, and would love to have you keep up on the progress there. Next, we're going to turn to NCLA's lawsuit against the governor of New Jersey. You heard Harriet mention at the top that the governor of New Jersey admitted on television that he hadn't considered the constitutional implications of what he was doing, and he really should have, because in our case, Matthew Johnson v. Governor Philip Murphy, we point out that the governor does not have the power to change the landlord-tenant law on his own in the state of New Jersey. But what he has tried to do is to tell tenants that they can use their security deposit in lieu of paying rent. And again, that's not something that contradicts existing statutory law in New Jersey, and he's just trying to change that on his own. To talk with us about this lawsuit, there are two of the attorneys involved, litigation counsel Kara Rollins and staff counsel Jared McLean. Kara, let me throw the first question to you. Why is it a problem for landlords to make this, or rather for the governor to have made this edict about security deposits for landlords?
It's a massive problem. So New Jersey operates a pretty comprehensive statutory scheme that governs the collection, maintenance, use, and debits against security deposits. It's something that's incorporated into, or required by law, to be incorporated into every residential lease in New Jersey. And when we're talking about scale, which is something that I think folks say, well, why does this matter? Why is this a big deal? To give you a concept, in New Jersey, when you're dealing with landlord-tenant issues, a lot of this is security deposit cases. The docket that handles that in state court has about 173,000 cases a year, just dealing with similar issues to this. It's not saying that they're all security deposits, but that's a significant number in a normal year. By modifying the statutory scheme that the state assembly and Senate set out, that's going to create a whole other sort of flood of issues regarding how are folks going to handle what happens next, right? What happens if a tenant decides to use the provisions set forth in Executive Order 128? How do landlords actually recoup? How does this interact with the remaining provisions of the statutory scheme that the governor's order didn't change? Again, thinking about scale, one of the things we look at is, well, how many units are in New Jersey? The estimate is about, give or take, $1 to $1.3 million rental units in New Jersey, which creates the possibility that there have been 1.3 million contracts that have been modified by the governor's action. I mean, these are private contracts, and that's a problem.
Well, and Kara, is it right to say that just because the tenant may have be able to use the security deposit to pay that rent, that doesn't necessarily enable the landlord to make its mortgage, particularly if the security deposit only covers 1 month's rent? A lot of these tenants we're hearing about have just taken this as a sort of a free opportunity to stop paying rent for the last few months.
Yeah, and that's an interesting thing that came up after we filed the case. We started hearing from landlords across the state saying, my tenant did that, and then my tenant stopped paying rent. So there's a compiling issue, and there's no requirement to show that you're suffering harm. You simply have to notify your landlord. And this just becomes an issue for the landlord on the back end of how do you recoup these losses? And I think in many cases, they're not. Most landlords, in some of the data that I've seen, it suggests that the majority of units in America, and we can kind of extrapolate down to New Jersey, our rental units are owned by folks that own less than, I believe, 5 units. So these are small landlords who are using it maybe as a supplemental income. Maybe it's a house that they didn't sell in the last downturn. I mean, there's a whole bunch of reasons why folks end up in these situations, but we're not talking about, I think, and Governor Murphy said a couple of things, but they're not these wealthy landlords that are trying to harm people. They're other folks and small businesses just trying to make ends meet like everybody else in this scenario.
Sure. Jared, maybe I can throw the next question to you. What legal objections is NCLA raising to Governor Murphy's order?
Yeah, our 2 main legal objections are under the contracts clauses of the United States and the New Jersey Constitution, and then we also have what we kind of call a waiver of law claim. And I'll start with the contracts clause issue because, like Kara was mentioning, the landlord and the tenant have entered into a private contract that accounts for the security deposit, and the security deposit serves a purpose. After we filed our lawsuit, one person reached out to us, and they had 4 tenants in a college town who were paying, rent was $2,000 a month. They said, we saw the governor's order, put our security deposit toward the last month's rent, and then they vacated the premises. He goes in, there's $1,800 worth of damage. The contract should have allowed him to keep their security deposit to cover that damage. But because Governor Murphy has modified the terms of their contract, if he tries to keep their security deposit, he's now violating a criminal law in New Jersey. So it alters the contract rights of private parties. And that's something in the founding that our founding fathers tried to avoid. When we were under the Articles of Confederation, states were accused of picking winners and losers when contracts went bad. And so the founders said that no state can alter the terms of a contractual relationship except under very limited circumstances. And that's exactly what Governor Murphy did here. And the other things, kind of similar to what Mike was discussing earlier with the Massachusetts case, there's no authority under New Jersey law for him to do so. The New Jersey law, similar but slightly different to Massachusetts, gives the governor the power to certain emergency powers that have to do with things like war and state defense, the National Guard, the state militia, what to do, like how to control hospitals in the case of a pandemic, but nothing at all has anything to do with residential leases, and there's simply no authority in the state constitution that allows him to legislate through executive edict. So we brought a claim both under the New Jersey state separation of powers article and just that this was an unlawful executive action.
Is there also a problem, Jared, with the fact that this particular edict covers residential landlords, but it doesn't cover commercial landlords?
Right, in administrative law, you hear arbitrary and capricious a lot, and the governor didn't really explain why he picked the winners and the losers that he did. He just sort of, and if you listen to his press conferences, he frames residential landlords specifically as being these sort of boogeymen who are out to take your money from you. And as Kara mentioned, as we've seen, a lot of these people are mom and pop operations, and now they're not able to pay their own mortgages because the governor has decided that they should bear the burden of the financial downturn.
Kara, last question for you. Are there any other legal objections that NCLA is making here that you wanted to elaborate on?
Well, so we have, and this is kind of piggybacking on part of Jared's previous answer, is that separation or the arbitrary distinction between residential landlords and commercial landlords is really an equal protection issue. That they're just treating people differently, treating landowners differently than other landowners on an arbitrary distinction. We also brought claims under the Due Process Clause of both the New Jersey and federal constitutions. And that has a lot to do with the idea that they just, it's akin to the contract clause issue, but slightly different. It's the state, as Mike said, the state legislature was there, they could have done this, and the government just did it by edict anyway. And that created a whole set of issues, including the criminalization and some other aspects of this that are really due process violations in this instance.
Well, thank you, Kara. Thank you, Jared. I think we're going to have to turn now to the next case. This is a case in which NCLA filed an amicus brief. Elkhorn Baptist Church v. Governor Catherine Brown. Governor Brown is the governor of Oregon. And this, the Supreme Court has already ruled in this case and has ruled that even though there's a statute in Oregon that limits emergency declarations to 14 days, which could be extended once, so for a total of 28 days, and even though the Constitution has a similar limit of 30 days, Governor Brown has run long past that 28 to 30-day limit and is continuing with her emergency declaration. And she says she gets to do it unless and until the legislature votes to stop it. And here to talk with us about that case is Senior Litigation Counsel Richard Sam. Rich?
Thank you, Mark.
Is there any way to stop Governor Brown now that the Oregon Supreme Court has said that the legislation and the Constitution that had these automatic 28 and 30-day provisions in it aren't enough? The Supreme Court says those actually don't prevent her from continuing with the emergency.
Well, as you mentioned, the only way to stop it is for the legislature to come into session and vote to stop it. But right now, the legislature is not in session and the governor has not called them into session. So it's sort of a catch-22 situation. I think Oregon is unique in that the voters of Oregon actually addressed the issue of public health emergencies. It actually anticipated that it might be necessary for the governor of the state to issue emergency proclamations on short-term bases because perhaps the legislature couldn't act quickly enough. So the statute that was adopted in 2003 gives very specific powers to the governor to do exactly the sort of things that she did. But as you mentioned, those emergency powers are limited to a maximum of 28 days. So the obvious implication of the statute is that the governor, as soon as she issued her emergency proclamation, should have called the legislature into session, and she could have done so. She has that power. Instead, she simply decided to operate indefinitely by emergency decree, and then when it came time to get the case in the Oregon Supreme Court, she said, well, it just would be unfair to the people to issue a preliminary injunction against my actions, because that would cause all sorts of potential public health problems. But of course, this was a problem of her own making, since she could easily have called the legislature in session.
Is it fair to say that the governor is operating with a pretty free hand right now without, I mean, there aren't any other sort of restrictions in place that prevent her from ruling? Because if I remember correctly, when we were talking about this case, the legislature or the legislation also seems to talk about having an emergency in a particular area, as though they're thinking about a hurricane or a tornado or something like that, not necessarily statewide power, but she's exerting statewide power now.
That's correct. There is a 1949 law on the books that says in a general emergency in a particular area, like a hurricane or a flood or something like that, the governor does have the right to invoke the state police powers, and that is the statute that she has been trying to operate under. But it's very clear that public health emergencies such as the COVID-19 emergency were not what they had in mind, and that's exactly why they passed a new law in 2003. But the 1949 law doesn't really specify what those police powers are, so one would normally think you would look to the more specific statute for the details of what she is permitted to do. But because the powers granted by this 1949 law are so vague, there really is no way for anybody at this point, now that the Oregon Supreme Court has ruled, there's no way for them to step in and try to say that she has exceeded some granted powers, because that law doesn't really specify any granted powers.
How do you think this shakes out in the end, Rich?
Well, I would bet that the same legislature that passed the 2003 law and the same group of people who, through a public initiative, passed a 2012 amendment to the Oregon Constitution that explicitly ratified this idea that the governor had short-term emergency powers, will come back to the amending process and be more specific about what the limitations are of a governor in future emergencies. Unfortunately, what I thought most people thought was quite clear limitations on those powers were essentially ignored by the Oregon Supreme Court this time around.
Yeah, it sure looks that way. Well, let me shift gears, Rich, and stick with you on another case that NCLA has been looking at, or at least another issue we've been looking at. It's not just the state governors or the state governments that have been a problem during this pandemic. There's been an interesting problem created by, right at the beginning of the pandemic, created by the Food and Drug Administration, and its claim that it has regulatory authority to regulate something called lab-developed tests. Now, these are not the tests that for COVID that are sent to a person's home, that you take it home and then send back. These are tests that are actually conducted in the lab by physicians, by lab technicians, in order to diagnose what a person's condition is. And Rich, you can explain this better than me, but I understand that because of the FDA's regulations in this area, some of the labs in Washington State, who were right on the cutting edge, ready to identify COVID-19 in its earliest days, were pulled back and told that they couldn't do what they were doing.
That's correct, and I think this is not an instance of the federal bureaucracy purposely standing in the way of testing. Rather, it was just simply the fact that when you have a large federal bureaucracy, that it oftentimes, just by its nature, stands in the way of science. doctors don't think that they are medical devices. They think they are medical practitioners. But FDA in recent years has been arguing that these laboratory developed tests, also known as home brew tests, are devices, and therefore perhaps FDA can regulate them, but they've never really tried to enforce that, and they have allowed these laboratory to go ahead with developing tests because those laboratories play an important role in developing quick diagnostic tests. Generally, you want to be able to get these tests out in a matter of days so that health officials can know the extent of the problem. But in this case, FDA thought it would help out, and it would invoke a public health emergency at the end of January, and that it would say, oh, well, anybody who wants to do something to help solve the COVID-19 crisis can go ahead and get what's known as an EUA, an emergency use authorization from us, and that will allow you to start doing things like having diagnostic tests. Well, perhaps EUAs were appropriate for companies that wanted to go out and market testing kits that they would send out to the public. But when it came to these laboratory developed tests, it created a new roadblock that didn't exist before. The result was, for example, as you mentioned, scientists and doctors at the University of Washington by early February had developed very effective diagnostic tests, much more effective than the flawed tests that the CDC had started to develop in early February. But because of this EUA requirement that was imposed by FDA, it meant that nobody was able to get approval to do that testing, and they didn't get approval until early March. So throughout the critical period of February of this year, no testing virtually went on anywhere in the country, and particularly in the state of Washington, where there was an early problem with the outbreak of COVID-19, it probably could have made a significant difference if the Washington laboratory had been able to do this test. They had the capacity to do thousands of tests daily in-house, but thanks to the FDA bureaucracy, they were delayed for a full month.
And thank you, Rich. I think we'll have to leave it there. It sure looks like this contributed to the inability to get out in front of testing in the United States. I'll note that one of the countries that is sometimes pointed to as having done a particularly good job of getting out in front of testing is Germany. And in Germany, they have a federal system, much like the United States has different states. And one of the federal, I'm not sure if it's provinces or states, I guess they're called states in Germany as well. But the one of those developed a test early on, and then it was working, and they shared it with the rest of the country, and that was what enabled them to get out in front of testing there. So the federal bureaucracy is very much to blame for the slowdown. And as Rich said, not because they were trying to be roadblocks, but because of the way that the laws had been written. Following those laws ended up creating quite a slowdown in testing in a way that was very unhelpful at the beginning of the pandemic. There's another agency that has created some roadblocks. When Congress passed the Paycheck Protection Plan, the Small Business Administration wasn't content with the restrictions on funding that were put in place by Congress and decided to add some additional conditions itself. Well, these kinds of conditions on spending are something that NCLA pays very careful attention to, because we believe that legislation should only be done through constitutionally prescribed channels and not by bureaucrats or administrative agencies who have not been, who don't have the authority to add or subtract from the legislation that Congress has produced. So NCLA has a case called Carmen's Corner Store v. Small Business Administration. And here to talk about that case are NCLA Senior Litigation Counsel John Vecchione, and once again, Staff Counsel Jared McLean. Jared, let me throw the first question to you. Why did the Small Business Administration add these additional constraints on the PPP program, and how is this affecting NCLA's client?
It's a good question, Mark. The short answer is we don't know why, because SBA didn't explain why it was doing it. Congress placed two conditions on these PPP loans. They told SBA to expedite this program, draft a rule immediately, start getting these loans out the door because businesses were really suffering. And they said anyone who's been in business as of February 15th, 2020, so you can't just create a new business to get free government money, and anyone who's had employees on the payroll is eligible for one of these loans. And SBA said, wait, here's a list of other people that are ineligible anyway. And they didn't actually explain why. And part of our lawsuit goes to the fact that they haven't offered a cogent explanation for why they chose to exclude these businesses. We can surmise that SBA doesn't think that people on its list of ineligibility are worthy of SBA loans. And our client, Altamont Wilkes, who owns Carmen's Corner Store and Retail for Real, he returned home from a felony conviction a little over 2 years ago. And SBA said that if you have a prior felony conviction, if you're on probation or parole, and there's a whole list that will make you ineligible for a PPP loan, and they haven't offered an explanation for why. They've changed the rule. First, it started as if you've been convicted of a felony in the last 7 years. Then they changed it to 5. Then Secretary Mnuchin testified before Congress that, okay, we'll change it to 3. And then last week, after we filed our lawsuit, they said, okay, we'll change it to 1 year. And they've really offered no explanation this entire time. And as to how it's affecting our client, like I mentioned, Mr. Wilkes returned home from prison 2 years ago. He started his one small business, Retail for Real, logistics business, immediately. And then he got funds together so his family could self-fund and open this corner store in his low-income neighborhood because there was a food desert, and they were providing food and soft drinks and stuff to people in the neighborhood. And I think a lot of people are familiar with the stats that most small businesses fail within 2 years. You had a pandemic and government forced closures on top of that. And it's just not very likely that many businesses are going to pull through. I think we've all seen businesses around us shutter, and that's exactly why Congress passed the PPP and told SBA to get it to these small businesses so quickly. And Mr. Wilkes has told me that he's been inside his store while it's closed and watched his customers have to walk 6 to 8 blocks to get to a Sheetz to buy food because they don't have any other option. And so he's literally watching the business that he's missing out on as he doesn't have this loan available to him. And the other thing to keep in mind—
But Sheetz does.
But Sheetz does, right. Right. And the other thing to keep in mind is that this is the Paycheck Protection Program. So it's not just Mr. Wilkes who this rule is hurting. All of his employees and all the employees of businesses owned by persons with criminal records have been excluded from this program as well, and they're not getting their paychecks in the mail, and that just puts more people on unemployment, more business uncertainty, and it's really just created this entire mess that Congress had tried its best to solve, and SBA completely bungled.
And John, I know that you're talking to another potential client, and I don't know how much you're comfortable saying at this point, so I'll leave that up to you. But I understand that there are other restrictions in the PPP program that may be affecting other folks in unintended ways as well because of SBA's overzealousness here.
Yes, I can't talk about it. This is an unfiled case yet, but out in Austin, we have a client, Mike Lockery, who owns the majority of Move Corp, which is a commercial moving business. And he had the unfortunate circumstance that he was pulled over for a DWI in early 2019, and his case was coming to trial just as COVID-19 broke out. Under Texas law, this would be a misdemeanor. If he was convicted, he could get funds for his company. But because of COVID-19, the Texas courts have slowed down prosecution of misdemeanors. They're not doing them. So he can't get it adjudicated. So he had to fill out one of these forms by the SBA. The question 5 said, "Are you under indictment?" He said, "It's an information, a criminal information, but it's the same thing." And so he replied yes, truthfully, and his bank had turned him down. And they were very apologetic. They said to him, look, this is the rule. If you answer yes, they aren't guaranteed, we can't give you a loan. So I call this, he has a charge against him, just a charge, hasn't been adjudicated. He's an innocent man. And this innocent man answers this truthfully for a crime that if he was convicted, he could get funds, but he can't get funds because COVID-19 has closed down the Texas court. I called this a COVID-22. So we are hoping that our suit will show how crazy this is. And it all emerges from the fact that SBA made these rules that don't come from the statute. Congress didn't want this. Congress, as Jared was saying, wanted the Paycheck Protection Program. He's got 40 employees, and he's made a promise to the employees. He said to them, look, he thought he was going to get these funds. He said, listen, I'm going to make sure you all get paid the same thing you got paid for the prior 6 months as we go forward, even as the moving business is really slowing down for obvious reasons. And so it's been a tremendous financial hardship. It has no basis in law. And the Small Business Administration is supposed to be helping small businesses, not putting roadblocks that do nothing to protect the public fisc, but gum up the works of moving forward with your business the way Congress wanted.
John, how do you see this shaking out with the SBA's rule?
Well, if the rule continues as it is, and as Jared has pointed out, they keep changing it. They've changed it a number of times. I think they'll change it again maybe today or tomorrow. But the fact is, if they don't change it, I believe that in this case, any court looking at it is going to say to the SBA, what good does this rule do, and where did you get the authority to do it? And I think they're going to have some hard questions to answer.
And Jared, coming back to you briefly, there have been some other cases around the country on this question, and SBA seems like they're on quite a losing streak.
They are. The cases mostly started with strip club owners. There were about 53 of them in Wisconsin and Michigan who brought lawsuits because that was another type of business that SBA excluded from the PPP program with no basis in law. And the Western District of Wisconsin, the Eastern District of Michigan, the Sixth Circuit have all said that this was an unambiguous statute. And even if it was ambiguous, you get no deference on this because this is not. There's just no reason for you to do it. Congress passed this to help all small businesses. If SBA was worried about loans being repaid in other circumstances, these are fully forgivable loans. Congress wasn't looking to be paid back for them, so there's no reason to be saying like these people might not be paying back this loan that's not supposed to be paid back. It makes no sense.
So in the strip club cases, they found it was nakedly unlawful.
Was that what they said, John? Well, I think we'll leave it there and move on. There's a couple of other cases that I wanted to get to, but before I do that, I wanted to give Jessica a heads up that if her microphone's working, I'll come back to her after this next issue and give her a chance to chime in on the Massachusetts case. But first, I wanted to turn to NCLA litigation counsel Caleb Kruckenberg, who has been following a couple of interesting matters. Let's start with the first one, Caleb. I understand that the city of Daytona, Florida was using pandemic drones, or at least said that they were going to, in order to take people's temperature in public without a warrant and so forth, and that you sent them a letter and said that might not be a good idea. Can you tell us about that?
Well, sure. And, we're having a conversation today about Governors Gone Wild. This is not a governor action, but this is Daytona, Florida. So, I suppose it fits there. But, this is a situation where we have a local law enforcement agency taking the pandemic as really an excuse to violate constitutional rights. And, as you mentioned, what they did is they set up a drone that could read someone's temperature, and the city police department flew it around the beaches and focused it on people in public. to take their temperature. And the idea, they said, was that they wanted to see if somebody had a fever, and if they did, then they would have law enforcement go and do something. Who knows what? Unfortunately, this is completely unconstitutional. The Fourth Amendment protects a lot of different things against government intrusion, and one is it protects us in our bodily integrity. And what I mean by that is, the government can't take your breath, for example, without suspecting you of sort of criminal activity. So you can't get a breathalyzer for no reason. The other thing is you have a constitutional right to the privacy of your health information. The government can't take your DNA without a good reason. And these are very well-established principles. And, there's another principle that the Constitution, or that the courts have recognized, is that police can't get around these constitutional limits by using new kinds of technology. And there's a famous Supreme Court case where the court said that police aren't allowed to use an infrared camera to look inside someone's house to see if they're growing marijuana or using heat plants to grow marijuana. The reason is the police can't go into your house in the first place, so they can't use a camera to look inside your house. Well, it's the same principle. If the police can't take your temperature by putting a thermometer under your tongue for no reason and you're in public, they also can't fly a drone around your city and take your temperature and take everybody's temperature just to see if you're sick. And so, like you said, we sent them a letter because it's completely inappropriate. And fortunately, what we've heard back is that the city has wisely realized that this is constitutional, and they've backed off.
And I think they're not the only city. There was a city, was it Westport in Connecticut, I believe, that had said that they were going to do the same thing. Sometimes I think just the boys with their toys get ahead of themselves in terms of, much like Governor Murphy in New Jersey, they don't think about the constitutional consequences of using the latest and greatest toy that is being offered to them by some vendor.
That's right. And I think this is something that NCLA has seen before in some of our other work, and we have lawsuits also in Florida against invasive surveillance practices by cities and local police departments. And I really do think that it's an issue of they have the technology, they see the pandemic, they see the problem, and they say, let's just put it together. Let's use it in this new way, without ever really thinking about what that means and what that means for constitutional rights and the civil liberties of people in their communities.
Well, if I can switch gears, Caleb, I wanted to ask you about one other case. I know that you're a Pennsylvania attorney, and NCLA is looking very hard at the case that the state legislature, or at least the state Senate, has brought against the governor of Pennsylvania. And I believe the governor asked the Supreme Court to assert its King's Bench jurisdiction, and the Supreme Court agreed to take the case directly. This case is called Scarnati et al. V. Wolf, Tom Wolf being the governor of Pennsylvania. And briefly, as I understand what's happened there, it's a little bit like the Oregon situation, except in Pennsylvania, the legislature actually did vote. Both the House and the Senate voted to end the emergency declaration, and the governor said, no, I don't think so. And his contention is that any sort of concurrent resolution that comes out of the state legislature is subject to being vetoed by the governor, and he's essentially asserting a veto and not going along with it. Is that an accurate description of what happened, and why does the governor think he can continue this emergency when the legislature has vetoed it?
Sure. So what we're seeing in Pennsylvania is a constitutional crisis really unfolding in the state. And what's happened is, as you mentioned, there's a statute on the books that says that the governor can declare a disaster and use emergency powers in a disaster declaration. That statute also says that disaster declaration can be stopped at any time by the legislature with a concurrent resolution. And that's exactly what the legislature did. The House and the Senate in Pennsylvania both passed a resolution saying the emergency is over, and we are overriding the governor's powers here. And the governor's come back and he said, not so fast. The Pennsylvania Constitution says all legislative actions have to be signed by me, and I'm refusing to sign it because I think I'm right and I think you're wrong. And it's a very extraordinary situation where the Pennsylvania Supreme Court has exercised its king's bench power. And what that means is they have taken this case. No court has ruled on it yet. They've taken it directly because it is a constitutional battle between the two other branches of government in Pennsylvania. And it seems that the governor is on very shaky footing here because he's saying essentially, even though this statute makes it very, very clear that I can declare an emergency and the legislature can overrule me, he's now saying, actually, I can always overrule the legislature no matter what in situations like this.
Yeah, it's distressing, and I think it probably raises a non-delegation concern as well, because if it's the case that the statute that the legislature passed gave over that kind of unconstrained legislative power to the governor, then that original piece of legislation would violate I know the Pennsylvania Constitution, I believe it's Article 2, Section 1, has a provision very similar to the U.S. Constitution, Article 1, Section 1, vesting legislative power in the legislature, and they shouldn't be able to give that up to the governor. So I would think that that would be potentially an additional path for the state Supreme Court to take in reining the governor in here.
That's absolutely right. And even if the governor's right, like you said, even if this is somehow the correct reading of this statute, essentially it would make it meaningless. It would mean that the legislature passed a statute that said we can stop this disaster whenever we want to, except we can't now. And right. That seems completely irrational, and it seems contrary. Pennsylvania has a very long tradition of upholding non-delegation issues. They have a very developed body of law where they respect the legislature's unique role here.
Well, and it's a shame that the governor is pushing this the way that he is, but maybe he looked west and saw what Governor Brown got away with in Oregon, and he's trying to do the same thing, because I know these governors pay attention to what's happening in the various states. And as I said at the outset, it's one of the reasons that NCLA has decided to get involved, because these cases have gone beyond just aggressive uses of police power, and they've started to violate structural restrictions that were put in place by legislatures, by constitutions, by, in some cases, popular initiatives and that kind of thing. And the governors are just running a roughshod over these. Jessica, if we have you back with us now, maybe we'll just end by where we began, talking about Massachusetts. I know one of the folks that we talked to up in Massachusetts said, I love Charlie Baker, but he's not my king. And Mike will hopefully forgive me for my attempt at a Massachusetts or Boston accent. But Jessica, what have your conversations been with clients up in Massachusetts, and how do you think the situation there is going to shake out at the end?
Yeah, well, I have to thank you for taking a shot at the Massachusetts accent. You pulled it off a lot better than I could. But so with talking with our clients up in Massachusetts, it's undeniable that COVID-19 caught us flat-footed, and there was a lot of uncertainty in those initial days, and it called for quick action. But we've been, now we are over 100 days away from the governor's first emergency order. And so we need to start moving beyond the emergency phase. And our clients want to find a balanced constitutional approach to combating the virus without infringing on civil liberties. And at this point, our clients are desperate. They're entrepreneurs who built their businesses by fixing problems, and the governor's orders are preventing them from fixing problems right now. But our clients are also resilient and brave. They're standing up to the governor, and I'm just very thankful that NCLA is allowed to represent them.
Thank you, Jessica. That's a terrific note to end on. And we will throw it open now to Q&A from the audience. So if you have a question that you would like to ask, go ahead and raise your hand. And let's see, I'm going to jump over to the attendees panel now so I can see raised hands. There's one question in the chat box, so let me throw this question out to the group and see who might want to answer it. The question for those who don't see the chat box or who may have called in is from Deborah, and Deborah asks, once our governors, and she's talking about Arizona here, she said, once our governor's executive orders expired, he relegated this authority to local county and city governments who are establishing proclamations with misdemeanor charges and fines up to $2,500 and 6 months in jail. Was the governor legal to do this, and local governments legal to do this? Well, let me take a crack at that, Deborah, and then if one of my colleagues wants to raise their hand and answer that question, I'll throw it to you. But we probably need a little bit more information to answer that, Deborah. What we've discovered in looking at these different states is that there really is quite a bit of variance from state to state. And what we would want to figure out is whether there is statutory or constitutional authority for that kind of delegation from the governor to the local and county officials. And sometimes there is the ability to delegate to a certain extent, but there may not be the ability to set fines or to change the penalties that are associated with a particular offense, that kind of thing. And so we would have to look at that more closely, but I am intrigued by that. My dad lives down in Arizona, and I know that he's been keeping me up to speed on particularly when golf courses are open and closed. It seems to be the most important factor for him. But Mike, I see that, well, actually, let me go to Adi first. Adi, I see you have your hand up, and since you are our resident Arizona lawyer, let me get your take on this first.
Yeah, thanks, Mark, and I apologize for some video camera troubles. But as I was thinking through the question that Deborah asked, the thought that occurred to me, in addition to what you mentioned, Mark, was the fact that the authority that the county and city governments have been invested with by the Constitution itself, it comes from Article 12 and Article 13 of the Arizona Constitution, is legislative in nature. It's the County Board of Supervisors and the City Council and the mayor that exercise their legislative authority in issuing any pandemic-related orders in this context. So from that perspective, what the governor has done in the state of Arizona is probably a counterpoint to some of the governors gone wild examples that we have discussed in this hour. He has recognized or empowered the local legislatures to essentially issue a legislative response at the local level, because Arizona being a state where, you know, a situation in Greenlee County would be vastly different from a situation in Maricopa County, for example. That sort of local response, legislative response, should be welcome and appreciated. But at the same time, I think there are some structural concerns that require uniformity at the state level. So for example, lack of due process protections, or if city governments and county governments are making it impossible for people to challenge or appeal these pandemic-related local orders, then that could become an issue, and that's an issue on which the governor at the state level can intervene. But from what I have seen in Arizona, the governor has empowered local governments to take legislative action on these sorts of issues.
Mike, did you want to jump in on that? We do have one other question in the queue.
Just quickly, I agree with your analysis, Mark, and I just wanted to give a just brief example, the difference between Massachusetts and Rhode Island, because we spent some time looking at Rhode Island, and in Rhode Island, you have a governor gone wild without a doubt, but she's taking the legislature right with her. The dynamics in just a few miles, they share a border together, and the Rhode Island legislature has handled this entirely different than the Massachusetts legislature. They also, the Rhode Island governor is also acting pursuant to a Military and Civil Defense Act, but the Rhode Island legislature amended that to allow the governor to have these broad civil defense powers in times of epidemic and dangerous infectious diseases. So it really is so specific to each state and each community.
Judy, I think that our next question is from Rhode Island. So do you want to open the line to our Rhode Island audience member?
Go ahead.
Stephen Findley, did you have a question? I can read Steve's question, but I wanted to give him a chance to ask it himself if he's on the line. I think you might be muted, Steve, on your end. Well, let me go ahead and ask the question. If Steve, if you want to jump in, go ahead. But let me just go ahead and say what the question is. It says, I'm a Rhode Islander. I cannot wear a face covering due to a medical condition. I don't drive and rely on public transportation and Uber to get around. It's 50-50 whether or not I get serviced from those two entities. I've explained that I'm medically exempt from wearing a mask, I think is what he's talking about. I've been asked for a slip stating that, and I explained I don't have to. I've been asked to vacate a bus because a driver didn't feel safe. An Uber has driven by me because I didn't have a mask on. 2 phone carriers refused to service me because of not being able to wear a mask. So his question is, short of filing a legal action, how can he get businesses to comply with the ADA or HIPAA, and how would we steer Rhode Islanders in the right direction so his civil liberties or other civil liberties aren't violated? And Steve, I think that's an important question. You're getting into something that's a little bit different than some of the cases that we've been talking about. I'll go to Mike here in a second, but I just wanted to point out that when you're talking about private businesses and what their requirements are, that's a different set of laws and constitutional principles that come into effect, whether it's an employer requiring employees to wear masks or a store requiring customers to wear masks. There's a different set of statutes and constitutional principles that come into play. That said, you mentioned the Americans with Disabilities Act and HIPAA as being a couple of statutes that might affect what those businesses are able to do with regard to their customers. And so I think you're asking the right question. I'm just not sure that the particular cases and research that we've been doing about restrictions on the governors and local authorities is going to give much insight into whether or not the problem that you're clearly encountering is something that we have a ready answer to. So, and I should just say too that NCLA doesn't sue private businesses. We are very concerned about the administrative state, and so our cases are all against federal, state, local governmental entities, usually administrative agencies, but as we've seen today, also sometimes against governors and so forth. So Mike, you went to college in Rhode Island, you're our Rhode Island expert. Do you want to speak a little bit to that?
Sure. It's heartbreaking, the number of people with whom I've spoken, both Massachusetts and Rhode Island, that have run into problems like this. And I think one of your questions is, short of going to court, what do I do? But that's what the courts are there for. They are there to vindicate your civil liberties. That's what we're doing in Massachusetts. And unfortunately, that may be the last resort. But one other bit of advice I've given to people with whom I've spoken who have similar questions and concerns and problems is that you really need to contact your legislators. This is still a legislative problem. Now, there's a solution in the courts, certainly, but then there's always the threat that this could happen again. And I think one of the things that we're trying to do at NCLA with all of these cases is make sure this doesn't happen again, because obviously some states are opening up, some faster than others. Some of these problems will go away soon, and hopefully they will go away soon. But our big concern is that, well, then what? What if the medical experts are right and there is a rebound in the fall or winter? But what about the next pandemic? Because there will be another one. There have been many others. Our governor is going to take advantage of this. And so in Rhode Island, I think it's particularly important to become politically active. and to lobby your legislators, ask them to repeal a statute that gives the governor this sort of authority to make these types of take these types of draconian measures. That also is a signal to private businesses that they can also be more exclusive with respect to the customers of people that they serve. So unfortunately, I think if you want satisfaction now and vindication now, that's only going to be through the courts. But thinking long term, I think you need to be a little more political. And I think there are a lot of people, at least the people with whom I've spoken, are very interested in preventing this from ever happening again.
Well, Mike, I think you make an excellent point that this could happen again, either several months from now when there's a rebound, or with the next pandemic. And I think that's another reason why NCLA jumped in and decided that as part of our mission to make sure that folks are only governed by legislation that goes through proper constitutional channels, that we don't see these governors operating by edict and operating in a way that allows the citizens to be governed by laws that didn't go through standard statutory or constitutional sort of processes. And I think that we see what happens when the Constitution is set aside, whether it's in New Jersey with what's happened with security deposits, or whether it's in Massachusetts, where some businesses are being told that they have to shut down until there's a vaccine, which essentially means your business has to go out of business. You have to go bankrupt, because those businesses won't be able to survive long enough to deal with that. And if the governor really has the power to do that, I think it's highly questionable. I don't think that's not how I read those statutes, to say that the governor can single-handedly make that kind of life-altering decision for citizens in the absence of legislation. That's just not the way that we are typically governed in the United States. And the one thing I would just close by saying is that NCLA was obviously founded long before this pandemic, and we've been working since 2017 on some of these issues. And I think it's sometimes difficult to see all of the damage that the administrative state is doing. Even though 10 times as many people, for example, are adjudicated in front of administrative law judges each year as are adjudicated in federal courts, it still may not be something you've experienced yourself. But I think everyone has experienced what's happened under this pandemic. Everyone understands, as a result of the edicts that governors have been putting out, what it looks like to be governed when the legislature is cut out of the picture. And there's a reason why our founding fathers insisted that legislators who have more local knowledge and more attentiveness to the needs and the balance of interests that may be not just health, but economic interests and socioeconomic interests, and part of health being human contact and not being locked up for months at a time and so forth. Mike, I don't think this came out today, but one of the things we talked about before was that the statutes in Massachusetts have always previously been interpreted that you can quarantine sick people, not that you can quarantine well people. And yet Massachusetts, the lockdown has applied to people who aren't sick. And that's not something that it's not clear in Massachusetts or elsewhere that there's statutory authority to lock down people who are not sick. And yet we've seen that happening. And I think that where I was going with that is that some of the administrative cases that NCLA works on are not ones that are readily available to people, or that they might just seem like something that's never going to happen to you. But I think that the principles that NCLA stands for and the need to really have legislation go through appropriate channels is something that we couldn't have a starker example of what happens when you abandon the constitutional approach that NCLA stands for. So I would invite folks who have been maybe educated or even energized or radicalized, maybe in some cases, by what's happening with the edicts by governors under the pandemic, to visit our website, go to nclalegal.org, find out more about the administrative state, find out about administrative power and some of the things that are happening at the federal level, and some of the other kinds of cases that NCLA was bringing before the pandemic that we're continuing to bring and that we'll bring after the pandemic. And that's also where you can go to stay up to date on any of these cases we've talked about today that you may care about and want to stay up to speed on. So thank you for joining us for this first virtual luncheon law, and we hope to have another virtual luncheon law next month. And God willing, we'll get back to having our in-person luncheon laws back at our offices on 19th Street in the very near future. Thanks again for joining us, and have a good day.